Arbitration. Everyone loves talking about it, not that many people actually do it. If you Google arbitration, you'd find all the law firms trying to tell you everything you need to know about it. But here are 5 things they don't tell you. Arbitration is great if there's a dispute between parties, perhaps a conflicting interpretation of a legal obligation. It's not so great for debt claims. In court, where there's a debt claim, you can apply for either a default judgment or summary judgment very early in the process, either because the respondent, the defendant, doesn't show up or doesn't raise an issue that deserves to go to trial. You don't have the same mechanism in arbitration. There is no knockout in this boxing match of arbitration. You have to go the full 12 rounds. And the recalcitrant defendant knows that you might run out of gas. When we talk about gas, we aren't just talking about your energy. We're talking about your financial resolve. Arbitration is a vehicle, and like any vehicle, it needs fuel to run. The fuel is the cost that you pay to run the arbitration. Now, for a claimant who's already out of pocket, it might have to pay further amounts to get the arbitration running. And if the respondent doesn't even take part, then the claimant is faced with this outrageous position of having to pay for the respondent as well, just so that it can get an award that may or may not be monetized. So the fundamental question before starting any arbitration is to ask whether you're throwing good money after bad. Arbitration is built on consent. Parties consent to the arbitration agreement, they consent to the appointment of the arbitrator, and so on. But this greatest hallmark of arbitration, it's also its biggest problem. The arbitrator only has jurisdiction over parties that have consented to the arbitration. It does not have jurisdiction over third parties that might not have consented. And this is particularly problematic in my world of international trade, where you have string contracts, back-to-back contracts, a web of actors and participants, shippers, carriers, lenders, surveyors, all with different contracts, and all of which the arbitrator might not have jurisdiction over. So getting evidence from these third parties may be tricky. This problem with third parties is particularly pronounced when it comes to interim relief. Let's say you have a defendant that you suspect is hiding assets or moving assets out so that you will have nothing to enforce against when you get your award. You would then want to get a freezing injunction to freeze the defendant's assets. You may get an injunction with a Singapore Arbitration Tribunal, but how effective is that injunction order against a third-party bank, let's say based in the Middle East or South America for that matter? In court, when you get a freezing injunction, there is a penal sanction contained with the freezing injunction that makes it an offense for a third party, such as a bank, to facilitate the breach of that order. That is why a court order freezing injunction is so much more effective than an arbitration freezing injunction. An arbitrator simply does not have the power to put a penal sanction into his order. Guerrilla tactics. It's notoriously difficult to penalize a party that engages in guerrilla tactics by not complying with directions. So, a defendant might not show up for the arbitration, it might miss deadlines, it might adduce new evidence right at the last minute, all with the sole purpose of frustrating proceedings. And it's not uncommon in arbitration to tolerate such behavior because there's a fear of the award being subsequently challenged because natural justice and due process wasn't given to the hearing itself. Arbitration is a great mechanism for international disputes, but it's worth bearing in mind that a fight is not always fair, and so these 5 problem areas must be borne in mind before commencing arbitration. I hope you found our update useful. Thank you, and have a great day.